Brian Delp in support. Okay. Kenneth McMark in opposition. Karen Graff in opposition. Russell Atkins in opposition. Mrs. Lau in support. Jack Manchrack in opposition. Okay. Michael and Leah McMahon in support. Carroll Wharton Cordero in support. Okay, anybody else wishing to testify on House Bill 1464?
Again, Richard Emery Community Association, State Legislative Action Committee, and President of Hawaii First. We oppose this bill essentially by putting several liability on volunteer board members who come from all walks of life. Probably within 24 hours of adoption, there'll be 0 board members in the industry anymore. These people are volunteering their time and effort to do a good job. They rely on management companies, they rely on professionals such as lawyers, they rely on their employees. This is such a broad bill with so much risk based on its definitions. We think it would be a serious mistake to adopt it as this.
Thanks for pointing out some of the flaws in the bill. I kind of agree as one of the writers of it. But I have to tell you, I do want to find some type of resolution. When 60% of my time, at least in my community now, it's statewide for some reason, where I'm getting mostly complaints regarding community associations in the state of Hawaii, saying that they harass them. I have great concern about that. And I'll give you a couple of examples, and then maybe you can help me walk us through. There was a member in a community association who took the board to court about a particular issue, and they won. Several months after that court case where that person won, every week for 6 months, the community association came to his house and measured the length of his grass for 6 months, every week. He proceeded to get deployed to Iraq. He hired a company to mow his lawn twice a month, which is the norm, except when it rains, the grass sometimes occasionally fertilizers added, it grows a little faster. He was fined on multiple occasions while he was in Iraq. I have other residents from another county who had called me and said that they were remodeling the front and putting things on, on the porch, and he also had problems with the community association before. And so he was fined for some materials just for one day being left out while they were putting new tile in the front. And I can just go on and on with these crazy stories. I understand your concern about the word harassment, and I think we should work with that. So Jane, you were saying that HRS 514B applies to situations like this. And can you explain a little bit more? Does it also apply to community associations as well that are not condos?
Well, the provision that I mentioned in my testimony applies to boards of directors. And what it does is that provision says that every board member has a fiduciary duty to the association and the members to act in a certain way. That section refers you to the business judgment rule in the corporate statute, chapter 414D. Okay, and in the business judgment rule, it basically sets out how you come to a decision. But I guess what you're describing is enforcement. And I have to say that I'm not that familiar with community association, but I would think it's the same with condominiums, so there's a violation. Usually when there's a violation, we do warnings. And after a certain number of warnings, then the fine system kicks in. But this is something that is in the house rules, in the bylaws, and whatnot. So it's not something that is arbitrary. And And I think with each association, it's kind of different because I've heard stories from, you know, from many over the years. Some associations, maybe because they're closer, you know, everybody knows each other, it's smaller. It's like, well, you know, instead of issuing the fines right away, they do the warnings, continually do the warnings. And at some point, it will stop. I mean, it's like, we can't keep warning you. It's not fair, you know, so we're going to issue this fine. And so I think it's just a matter of enforcement. If it's grass, if we're talking about grass, I would think that if somebody would just go and tell them, you know, just cut your grass instead of finding them.
No, he got the warnings. He got the warnings, but it was repeated. They literally targeted this person, retaliated against this person, and the person was in Iraq. I mean, you know, do you find that acceptable harassment?
No, not at all. May I comment? What you're describing is how to address renegade groups, basically. First of all, I think I just reaffirmed that existing law provides remedies. For one thing, there's harassment TROs. I mean, you don't need to create a body of law for that. I have a friend who, until he wised up and moved on to something else, was a condo attorney, and his condominium association fined him for his lawn, which he mows once a week. So I know that there can be applications that are difficult. The difficulty with this bill as drafted is that the terms are somewhat amorphic and they're subject to abuse, but that doesn't mean we're not identifying a realistic concern. Mr. Port, in testimony relating to a different bill, had suggested that there's not an available, readily identifiable group of attorneys that represent owners, because any of us who practice in this area represent associations, and it's hard to build a practice on the owner side of
Is
things.
it because the laws are so tight and cut and dry in favor of associations that lawyers don't find it profitable to help People who live in community associations?
I'm glad you asked that.
Because that concerns me.
Sorry.
So we're taking out that one section about the harassment and referring to the other section that already exists, or if we did. How about the section where it says a board member cannot financially benefit from their decisions? Let me give you a situation. There was several constituents called me about a board decision in my community where a board member actually sold their house and at a higher rate than normal during the downturn. It took board approval for her to sell this house because it was going to become a business. And she took that vote and lobbied the board to approve this house for a business, which is separate from the community association. Would it be fair to say that it's safe to say that we should put that in statute that board members cannot financially benefit from their decisions?
Again, I didn't prepare for the PCA statute this morning, but and I understand that's your topic. I think that there probably is some language relating to that, but the condo statute, for comparison purposes, requires disclosure of conflicts of interest and not participating in matters as to which you have a conflict of interest, which is absolutely appropriate. There should not be any benefit to a director by making association decisions.